Thank you all for joining us today. Thank you also to the co-sponsoring groups on this event, Associazione Luca Coscioni, Drug Policy Alliance, eHumans, Forum Droga, International Drug Law Advocacy and Resource Center, No Peace Without Justice, No Box Transitions Philippines, Philippine Coalition for the International Criminal Court, Students for Sensible Drug Policy, Veterans Action Council, and the Washington Office on Latin America. And a special thank you to Forum Droga's Leonardo Fiorentini for once again managing the event's technical matters. Today's online event, which is an official side event of the UN Commission on Crime Prevention and Criminal Justice, follows on a similarly named event we organized in person at the Commission on Narcotic Drugs last March. It is also part of a series of events focused on extrajudicial drug war killings, which began in March 2017, principally the Duterte drug war killings in the Philippines that have claimed the lives of as many as 30,000 people. Today, sadly, we also contend with extrajudicial killings by the Trump administration of my own government in the form of strikes and alleged drug boats in the Caribbean and Eastern Pacific, the number of which last week passed the 200 mark. But we also take heart from the example of the Philippines, where despite political turbulence and continuing human rights challenges, we are seeing that accountability and hope are indeed possible. With those situations principally in mind, we will hear today from one of the leading human rights attorneys in the Philippines and from two of our top legal minds here in the US devoted to accountability and the protection of civilians. It's important to remember, however, that these are not the only known extrajudicial drug war killing cases, and the phenomenon has a troubling international dimension. The first, or perhaps the first well-publicized one, took place in Thailand in 2006, when 3,000 alleged drug law violators were murdered at the instigation of then Prime Minister Thaksin Shinawatra. The Duterte killings were accompanied by smaller but significant outbreaks in Indonesia and Bangladesh. In 2019, OHCHR actually reported police in Venezuela committing a similar drug war killing spree. Perhaps inspired by the Trump EJKs, police in Rio de Janeiro last year committed the worst massacre in their history. It should be noted that the national government of Brazil has condemned those killings and has raised concerns about the US boat strikes. Now, the Trump administration's legal rationale behind the strikes remains confidential, but the justifications officials have offered publicly are internally inconsistent and are well out of sync with the accepted interpretations of all areas of both domestic and international law. Despite that, and despite the demonstrated lack of any productive impact, this has not, however, prevented defenders of the strikes from waxing self-righteously. One example was the ambassador from Trinidad and Tobago responding to a question posed by our UN representative in New York at an event last month. We'll also play from the same short video clip the very different response provided by the ambassador from Zimbabwe, the other Security Council candidate who was participating.
We also have the DRC Net Foundation. Yes, you have the floor.
Good afternoon. Thank you. I'm going to echo what my colleague across the room said, and thanks for allowing civil society voices in the room. We very much welcome this dialogue. I'm delivering this on behalf of two civil society organizations, DRC Net and the International Drug Law Advocacy and Resource Center. Since September of last year, the US military, in the direction of the current president, has engaged in a series of lethal strikes on civilian fishing boats that were allegedly carrying drugs in the Caribbean and Eastern Pacific. The 55 strike events so far, widely condemned in the US and the international legal communities as extrajudicial killings, have claimed the lives of 194 people, some of them Trinidad and Tobago nationals. 5 governments, including two of those permanent members of the Security Council, have responded to the strike by placing restrictions on the cooperation with the US operations in the regions. Following the initial strike, Prime Minister Kamala Bissar praised it, saying the US military should kill all drug traffickers violently. In later remarks referencing both the boat strikes and a territorial dispute between Venezuela, the Prime Minister attacked the CARICOM zone of peace, calling it vacuous. In light of the Security Council's mission as a safeguard for world peace, will both Zimbabwe and Trinidad and Tobago, in their work on the Council, condemn the extrajudicial killings and support the holding of discussions about the boat strikes or other questions internationally about counter-drug operations, should the Council consider taking up the issue? Thank you very much.
We begin with Ambassador Parsons.
Sure, and thank you both for the two questions. As far as the second question is concerned, I will close my book for this one. Trinidad and Tobago is 7 miles off the coast of Venezuela. We are deeply committed to our neighbors, and we are fully supportive of the people of Venezuela. We have recognized the interim president of Venezuela, Her Excellency Delcy Rodriguez. A great deal of crime and violence in my country emanates from drug trafficking coming from mainland South America. And I'm not yet to name and shame countries. But a great source of the crime and violence, as I intimated in my opening remarks. Trinidad and Tobago heavily debated the issue of international law when it came to the strikes on vessels outside our territorial waters. My Prime Minister wholeheartedly supported those strikes, again debating international law. And let me tell you two things. Number one, we had 627 murders last year, as I said earlier. Between January and February of 2026, yes, we had a state of emergency in the country. Our crime rate between January and February, as a result of those strikes and our state of emergency, dropped 42% between January and February, showing evidentially a statistical correlation between striking those narco boats and curbing the violence in my country. Thank you, moderator.
Thank you very much. And now I give the floor to Ambassador Shaya Von Hu.
Thank you, William, and thank you to the colleagues from civil society for those questions. Then in terms of the handling of the boats in the Atlantic, we think that this is really a question of human rights, that human rights have to be observed in all of these, in the contact of relations, in the contact of nations. So there is need for proportionality. That what we are dealing with, if it is a drug trafficking, it is dealt as such as trafficking, and that it's proportional, and that there is a respect for in terms of the handling of the aftermath of these eliminations, that there is respect for international law. So for us, that will be the response. I thank you.
Thank you very much.
We don't have time here today to address all of the statistical errors made by the ambassador, but I will just note that if indeed there was a crime drop in his country between January and February of this year, which I believe there may have been, but not a percentage he cited. Statistically, that fact on its own would not demonstrate anything. It's statistically meaningless on its own, and it certainly does not suffice to provide policy explanation. And I'll note that the ambassador mentioned they have been doing state of emergencies that he also attributes to crime drop, and those kinds of operations, perhaps temporarily, can have some impact. If their states of emergency were effective, then perhaps that would be consistent with the strikes having no effect on crime in the country, or having an effect. It's not that's not how one can analyze statistics. So with that, we will now turn to our panelists, from whom we will first hear about accountability options for the boat strikes from our U.S. experts. Now, note that the two of them have decided to interweave their presentations and speak alternately, so I'll introduce them together. John Ramming Chappell is an advocacy and legal advisor at Center for Civilians of Conflict. He engages with U.S. policymakers to enhance the protection of civilians and has coordinated advocacy campaigns regarding crises in Palestine, Iran, Sudan, and the Eastern Pacific and Caribbean Sea. His work focuses on U.S. law and policy related to civilian harm, arms sales, and the use of military force. John regularly writes for leading policy publications, and his commentary has appeared in the New York Times, CNN, NPR, Politico, and other media outlets. Sarah Harrison is a non-resident fellow in the Conventional Defense Program at the Stimson Center. Sarah has more than a decade of experience advising and writing on international and domestic law with a focus on human rights, the law of war, and use of force. As a senior analyst in the U.S. program at Crisis Group, Sarah researched, analyzed, and wrote about U.S. law and foreign policy and advocating for approaches to mitigate or end deadly conflict. Prior to her time at Crisis Group, Sarah was an associate general counsel at the Department of Defense's Office of General Counsel, International Affairs, where she advised on domestic and international legal issues relating to U.S. national security and the activities of the U.S. Armed Forces. And from 2015 to 2017, she served in the Obama administration as counselor to the Secretary of Homeland Security. So John and Sarah, you have the floor in the order that you've designated.
Thank you so much. So I'm going to start off by making a couple of short observations about kind of the roots of the current campaign of airstrikes on vessels allegedly carrying drugs in the Caribbean and the Pacific. I'll talk a little bit about the international law that governs these issues. Then I'll turn it over to Sarah to talk domestic law. And I think also probably Sarah you'll go into the international accountability options. I will end this portion by speaking about third state responsibility and individual accountability for aiding and abetting. So first, I want to start by noting, as David already has, that more than 200 people have been killed in U.S. airstrikes on alleged drug-carrying vessels since September of last year. Unfortunately, this has unfolded largely below the radar in recent months. While there has been periods of a lot of focus and attention on this issue in the United States, we're seeing that it has somewhat faded into the background, even as the human consequences of this policy increase and remain acute, especially for coastal and fishing communities along the Pacific and Caribbean coasts. I think that the first thing I want to offer as framing is that one way of thinking of this campaign is a metastasis of the global war on terror. The United States has long conducted a program of airstrikes, especially drone strikes outside of areas of armed conflict. And outside of those areas of armed conflict, it is human rights law, international human rights law that governs. Now, we are seeing increasingly the utilization of the framework of narco-terrorism by the U.S. Government and by the Trump administration in order to structure their response to drug trafficking or alleged drug trafficking. Of course, there's been a strong interaction between the war on drugs and the so-called war on terror for a very long time, but I think that we're seeing that fusion reach its natural conclusion, where the solution that the United States has advanced is really no solution at all. It is an application of the failed model from the war on terror to this fundamentally economic challenge of drug trafficking. It also comes at a time when the United States is increasingly asserting dominance and advancing a view of or advancing a posture of interventionism in the Western Hemisphere. The so-called Donroe Doctrine, a play on words of the Monroe Doctrine, it has become the framing principle for U.S. policy in the Western Hemisphere. And a key aspect of that so-called Donroe Doctrine is the unaccountable use of military force, whether in Venezuela or against alleged drug traffickers in the Caribbean Pacific. So, what does international law say about this? Well, I have worked on few things, I think, where the international law is so clear and where there is so much consensus around legal experts, to be honest. The US government is killing people outside of armed conflict with no due process. And there's a very uh, clear term for this in international law, which will be clear to many of you based on David's introduction, which is extrajudicial killing. Um, there is no armed conflict between the United States and the drug trafficking organizations it claims to be targeting. Um, Non-international armed conflict, that is, armed conflict between a state and non-state actor, is fairly clearly defined in international jurisprudence, specifically the Tadic factors that came from the International Criminal Tribunal for the former Yugoslavia. And it's clear that the intensity and level of organization does not rise to the level of a non-international armed conflict here. But again, the United States is using the frameworks of the global war on terror in order to expand and carry out this campaign against what they call narco terrorists. It's important to note that we have very little evidence that the people who have been killed are in fact carrying drugs. It's recently become clear that it's not even among the targeting criteria that the small vessels in question are carrying drugs. It's very possible that many of the victims of these killings are fishermen or other forms of merchants. And when it comes to the scale of the campaign that we've seen, 200 people, more than 200 people, at least, over the course of what is it, September to June, so 9 months, something along those lines. It raises the question of crimes against humanity as well. So crimes against humanity are one of the international atrocity crimes, along with genocide, war crimes, and the crime of aggression. There isn't a crimes against humanity treaty, but crimes against humanity are defined, for example, in the Rome Statute. And when it comes to crimes against humanity, the key question is whether the killings have happened as part of a widespread or systematic attack. And increasingly, it seems like they are. The longer that this policy continues, the more people are killed, and the more that the U.S. government systematically targets civilians. And it's important to say that these people are civilians, even if they are civilians who might be accused of or suspected of a crime. This case for crimes against humanity becomes stronger and stronger. And I'll refer you to some of the excellent writing that's been done by international law experts, former U.S. government lawyers, raising that these killings likely do amount to crimes against humanity. The administration claims that it is in a war, that it is in a non-international armed conflict against drug trafficking organizations that have supposedly conducted an armed attack on the United States. There's no legal basis for that claim. Armed attack does not include trafficking of drugs to a country. It doesn't even generally include the transport of weapons to a country. There is no real legal basis for the claim that has been an armed attack on the United States, that there is an armed conflict, or that the people being targeted are combatants. And so to wrap up this portion, I'll conclude again that it's eminently clear that the United States' airstrikes on civilians aboard boats in the Caribbean and Pacific are extrajudicial killings. This is, I'd say, uncontroversial among serious legal experts. And they I think, likely amount to crimes against humanity. I'll turn it over to Sarah to talk a little bit about what U.S. domestic law has to say about these killings, and also to lead us into the conversation about accountability.
Thank you, John, and thank you, David, for inviting me here today. And thank you, everyone, for joining us. So the domestic law is pretty straightforward. Like John said, President Trump wants to use a war framing so he can use force as a first resort. But there is no armed conflict. And unlike the post 9/11 conflicts that the US has engaged in and still engages in today, there is no domestic legal authority to use force against these suspected criminals or alleged suspected criminals, right? So there's no domestic legal authority. And that means that the US military could only use force as a first resort if these individuals posed an imminent threat to life or serious bodily injury of other persons, and they don't. And they've shown no proof of that. And they actually don't claim that these people are posing any imminent threat to people on the high seas that they're coming in contact with. They're only alleging that they are trafficking drugs into the United States. So the US military and US law enforcement, they can't execute criminal suspects in the streets of Miami and New York or any other American city. They can't do it on the high seas. That doesn't make it legal just because it's out in the middle of the ocean. And so these are, I agree with John, extrajudicial killings under international law, likely crimes against humanity, especially because these are government policies to execute criminal suspects. And that's a key point or a key element of crimes against humanity, that it's a government policy. So under US law, if the government is executing people without authority and killing people without authority, then criminal law applies. And so there are two statutes that I'll just quickly go over here. One is in Title 18, which is the US Criminal Code, which is our federal law, covers all covers the entire country, and it criminalizes murder. So it criminalizes when anyone unlawfully kills a human being with malice aforethought, and that includes killings on the high seas. And then there's also conspiracy as a standalone criminal charge that can be made under Title 18 if there is a conspiracy to murder. To commit the offense of murder, which is what this is. And so everyone in the chain of command is susceptible to being prosecuted in the future under Title 18 for committing murder when they execute individuals in these boats. Now, I'll talk in a second about the challenges to actually applying these domestic criminal laws. But the other statute I wanted to mention is the Uniform Code of Military Justice, which applies to our armed forces, which also prohibits murder of any person, any unlawful killing of a human being that is premeditated, and those individuals would be guilty of murder under the UCMJ, which like I said, all of our U.S. forces are subject to. The U.S. forces who serve in the U.S. military are, that's a little redundant. Anyway, U.S. service members are obligated to refuse a manifestly illegal order. And so I think what's confusing here for many who, I think for the American public and people who serve down the chain of command in the US military, is that the US, like John described, are conducting these drone strikes, which is a pattern of decades of US military operations. And so it doesn't feel the same as, if US forces were ordered to go on board these boats and, perhaps use a gun to execute individuals. I think forces would understand, service members would understand that is illegal. That's a manifestly illegal order. I think that the drone strikes really confuse people because they have been used for so long, and people are desensitized to their use around the world. So the domestic challenges here I think are probably obvious to many people. The president has the pardon power, and so he will likely pardon anyone who is implicated in these strikes at the end of his administration. which brings challenges. I mean, it would prevent them from ever being prosecuted by a future administration, anyone who received a pardon. And then there's also the challenge of political will. It's quite difficult, as many around the world saw after the Bush administration. It's quite difficult in the US to hold former administration officials or civil servants accountable for atrocity crimes like torture. No one was held accountable for torture. The Obama administration did do an investigation, a preliminary investigation into whether anyone should be held accountable, anyone should be charged, and they decided not to, and they decided to look forward. So there is a culture of impunity within the United States for crimes like this, and so I think it would be very difficult to ever actually prosecute in the United States. So I and two other attorneys recently wrote a piece in Just Security, kind of walking through all of the ways in which there might be international accountability for these crimes. And so I will just walk through them now for everyone. And then if there are questions, we can talk through them at the end of this presentation. But the first that we preview is foreign domestic courts. These make the most sense because for countries that have a passive personality jurisdiction, which means they can prosecute crimes against their citizens that have happened abroad, Venezuela, Trinidad, Colombia, Ecuador, all of these countries that we know where their citizens have been killed could investigate and bring charges against those responsible for these strikes. There obviously would need to be political will in these countries to do that. They would need to gather evidence, and I think one of the biggest hurdles is actually effectuating an arrest against anyone in the United States. Probably the biggest hurdle is bringing them into custody. And I think what's important to note here is, generally speaking, murder statutes for any country, they either have a very long statute of limitations or there is no statute of limitations. And so it's not like they need to bring any charges now. They could quietly collect evidence and shouldn't be deterred from trying to do so, especially to protect the citizens of their states that are being, the citizens of their country that are being killed. The real consequences, I think, here, which have happened after the Bush administration, when some countries were bringing charges against Bush officials, is the consequences of self-imposed travel restrictions and public condemnation, which I think are both still really meaningful. They're better than nothing. So that's the first, I think my colleagues who wrote this piece, Ben Farley and Tracy Begley, think is probably the best route. There's also foreign courts with universal jurisdiction who could bring a case. Universal jurisdiction means that the country can prosecute people for atrocity crimes, like crimes against humanity, like genocide and war crimes, whether or not the victim is a citizen of their country, the perpetrator is a victim of their country, or whether it doesn't matter where the crime was committed. That's why it's called universal jurisdiction. So it would allow for prosecuting people in the chain of command in the United States for crimes against humanity. And there's no statute of limitations, generally speaking, for UJ jurisdiction. And then there would be similar challenges to that, as I stated above, needing political will, collecting evidence, securing witnesses, and proving, having the evidence necessary to convict. Then there are the international bodies of the Organization of American States, the ICJ and the ICC. OAS, the Organization of American States, has a human rights commission that can review and investigate allegations of human rights violations by its states. And a family in Colombia did file a complaint in December alleging that their loved one was killed by an extrajudicial killing by the United States, and they are asking for compensation and for the attacks to stop. The commission hasn't ruled on this yet, but if it does, it's non-binding. though it will help bring public pressure against the United States. And we saw in March, after the commission had a hearing about the boat strikes and the illegality of them, the State Department acted quite forcefully in responding, saying that the commission was acting outside of its competence and it was interfering in domestic litigation because currently there is a civil case ongoing in the United States. Separately, there's a human rights court under the OAS, but the U.S. isn't a party to the treaty for that court, so the court has no jurisdiction over the United States. But there is a case to watch within the commission of the family that brought the complaint in December from Colombia. So then there's the ICJ. The ICJ, as many of you know, can issue opinions in contentious cases where states disagree on an issue of international law, but they must accept jurisdiction. The United States is unlikely to do that. They also issue advisory opinions, which are non-binding, but they do carry significant weight. And a UN Security Council resolution is one way to get an advisory opinion, unlikely because the United States can veto it. There is also a possibility to have the General Assembly vote on asking for an advisory opinion from the ICJ. The General Assembly would need a state or a coalition of states to gather together to push for this question of international law. This did happen recently, despite the US's opposition with respect to Israel's requirements to comply with international law. So the challenges are there, but they have been overcome in the past. And it is likely, and we talk about this in the paper, that the Trump administration would respond quite aggressively if the General Assembly moved to have a question on the boat strikes. But we still think this is quite important. And actually one of the best ways probably right now to push for an opinion on international law with respect to these killings, and might help, put pressure on the United States to put an end to this campaign. Then the last thing is the ICC. And the ICC can prosecute for war crimes, crimes against humanity, genocide, and crimes of aggression. And obviously here we would talking about crimes against humanity. And the big challenge would be jurisdiction. Obviously, the U.S. is not a party to the Rome Statute. And so the crime would need to take place on the territory of a state that is party to the Rome Statute. And that includes properly registered vessels. So if any of these boats that have been struck are properly registered vessels of states that are party to the Rome Statute, the ICC could have jurisdiction. The U.S. has been has a history of animosity towards the ICC, and so we would likely see that again if it moved to do any kind of investigation with respect to these boat strikes. The relevant example here is obviously Duterte, and I'll leave it there to have Dino weigh in on the relevance of the Duterte murder campaign with respect to the Trump administration's boat strikes.
Thanks so much, Sarah. I think I'll say a couple of words about third state responsibility and then go to Dino. Does that work? Yeah? Okay, cool. So Sarah has just talked quite a bit about accountability options for the people who have carried out the campaign of murders or extrajudicial killings. The thing that I want to bring in quickly is that the U.S. isn't acting alone. That we know that some states are cooperating with the United States in this murder spree. The Dominican Republic has confirmed their cooperation, Ecuador as well, and then a number of states have been vocally supportive of U.S. operations in the Caribbean and Pacific that have killed civilians. Trinidad and Tobago is one of those, and David showed that video earlier that shows one of the ways in which they have been vocally supportive. So both individuals and states can bear responsibility for contributing to the internationally wrongful acts of another. When it comes to states, a state that has made a significant contribution to an internationally wrongful act with a view towards facilitating it it can be responsible when they're aware of the circumstances around that act. Due to the highly public nature of this campaign, the United States has posted videos of their killings consistently. Almost all of them have been posted on Twitter, and you can see explosions in which people die, which is kind of devastating and upsetting, actually, when you think about it. The fact that the US government is not only uh, unashamedly communicating about these, but literally sharing videos of murders. That means this is happening in plain sight, even as it has faded from the public conversation. States have a good reason to know that their support is contributing to these actions, especially if they are communicating regularly with US forces. And the ways that they could be significantly contributing might be intelligence sharing, giving base access, or other forms of cooperation. This part of the campaign remains fairly murky in a lot of cases, but some states have already cut off certain forms of cooperation with the United States, the United Kingdom, and Canada being two that have reportedly done so. Individuals can also bear responsibility. And so in this case, we'd mostly be thinking about uh, senior members of foreign militaries who provide the assistance that is needed to carry out the extrajudicial killings. There's a slightly different definition for the mental element that's required under customary international law versus the Rome Statute, but under the slightly broader definition in customary international law, um, a person who makes a substantial contribution, who knew or should have known that that was contributing to uh, a serious violation of international human rights, can be responsible for aiding and abetting. This is something that all states should be keeping in mind as they consider what their posture should be toward this policy. And in addition to the primary perpetrators that Sarah has spoken about, there could also be accountability for the secondary contributors to this campaign. And that's it from me. Over to Dino.
So our next speaker is our next and final speaker is Dino Singson De Leon, a human rights attorney and a partner at the Dargon Law Firm in Quezon City, Philippines. He serves as trustee of the Human Rights and People Empowerment Center, NGO associated with Philippine Congressman, former Senator Laila de Lima, for whom he also serves as attorney and spokesperson. Dino earned both his Bachelor of Arts in Development Studies and his Juris Doctor from De La Salle University and was admitted to the Philippine Bar in 2015. He obtained his Master of Laws with distinction from Georgetown University here in Washington and completed certificate programs in both public and private international law at the Hague Academy of International Law, as well as the Chief Financial Officer program at Asian Institute of Management. Dino is a frequent commentator in Philippine media, and we are very pleased that he has decided to join us here today. So Dino, you have the floor.
Yeah, thank you very much, David. Can you see my slide?
Yes.
Yeah. Okay. So it's good to talk about the present case of the ICC, the present status, and of course the struggle of the Philippines insofar as the Philippine drug war is concerned, especially during the time of Rodrigo Duterte. And as it would be around 10 years by June 30, ever since Rodrigo Duterte became our president and started the bloody drug war and promised a huge massacre of our people. And I can't imagine as a human rights lawyer that one day, since I've been involved in the human rights struggle for almost 10 years now, that one day I would be able to say that accountability may only be a matter of time for Rodrigo Duterte. When I was talking to different forums, including forums organized by Dave before, and in other international fora, it's always so grim. It's as if justice is very far or almost an impossibility. But maybe I can say for now that accountability may only be a matter of time. No. Well, what does that mean to the Filipino people? As you know, we've lost count on how many people were really killed during the bloody drug war. According to Human Rights Watch, it's around 27,931. According to our own Philippine National Police, they call it deaths under investigation, 22,983. According to the chairperson of the Commission on Human Rights, it's around 27,000. The estimates of the International Criminal Court is around 12,000, 30,000. The sheer number of people who were killed during the brutal drug war was just so large that we've all lost count. Even the media lost count. And a lot of the victims were minors. A lot of the victims' families right now are still grieving and they don't know what to do. But of course, even if Duterte's case is already in the ICC, and as you know, we finally sent Duterte. We never thought that would ever happen, but we finally sent Duterte to the ICC with the cooperation of the current Philippine government. Of course, they were used to be allies, but when they were again on each other's throats, politics does that, but we'll take it anyway, because without the cooperation of the current Philippine government, Rodrigo Duterte wouldn't have been sent to the ICC. So he's now in the ICC, and he's co-perpetrator, the then Philippine National Police chief, because our police was used to brutally murder tens of thousands of people, is also named as co-perpetrator in the ICC. That's Bato de la Rosa. He's now in the Philippine Senate, and just a few weeks ago, the ICC warrant of arrest was unsealed against him when he voted for the change in leadership in the Senate presidency. He was absent for 6 months because he found out, at least he had advanced knowledge, that there might be a warrant of arrest against him. So he was been missing for the last 6 months. But when there was a change in Senate leadership and he was the deciding vote, because our Senate is composed of 24 senators, and it's going to be ranked 13th, or vote number 13, he all of a sudden showed himself, and then the ICC warrant was unsealed, and there was a chase. There was an actual chase in the halls of the Senate. So it's insane, actually. And then there was protective custody that was extended to him by the Philippine Senate. The Senate president whom he voted into power, and then all of a sudden at the wee hours of the night, there was a shooting incident. Apparently, it's a staged shooting incident by the Senate security, so that there's going to be a smoke screen that will be created so that Bato de la Rosa will escape, and we don't know where he is right now. That's how far and the kind of extent. It was like a telenovela. It was like a movie. Imagine shootings in your own Senate, what's supposed to be a bastion of democracy. That has never happened, not even in the worst days of martial law in the Philippines, that there were shootings in the Senate. But there were shootings in our Senate to allow Bato de la Rosa to escape. That actually demonstrates that the need for the ICC, because Duterte and his allies and his cohorts are so still well entrenched and very powerful in the Philippines. And we are just thankful that, there is an ICC, a mechanism wherein the victims can tell their stories. The victims can at least try to secure justice. No, so beyond legal restitution, of course, the pending litigation introduces a global and moral obligation for long-term rehabilitation to heal families fractured by extrajudicial violence. No, and it is important that alongside the trial in the ICC, there has to be a re-educating civic mindset, no? Especially for those who are apathetic or the supporters of EJK. Believe it or not, EJK, extrajudicial killings in the drug war, is still very popular in the Philippines. A lot of people still think, primarily because of propaganda as well, and of course Duterte support that it was fine to kill tens of thousands of our people without trial. And there are a lot of people who really don't care. So there has to be an education of civic mindsets. And we believe that the trial, once broadcast, at the very least would educate more people of the horrors of the and the horrific experience that these families had to go through, just in the name of a drug war, right? And in fact, this was part of the opening statement of the Victims' Counsel during the ICC trial. He said, and I quote, "The testimonies and evidence presented will hopefully inoculate these mini Dutertes, because Duterte created a lot of mini Dutertes in our country who are believers of violence, that it is justified to murder a lot of people, from the virus of impunity that has infected them. When they will see and hear the utter cruelty, the sheer brutality, in other words, the brazen inhumanity committed by Mr. Duterte, and the inhumanity of those whose lives were violently taken, it will rekindle the embers of humanity that still remains in their hearts, which is why it's important to hear their stories. And for the first time, the victims' families will be able to tell their story because they were never given the chance to have any kind of avenue of to tell their stories in our Philippine justice system, which is why we needed to resort to the ICC. Well, as you know, my client, Laila de Lima, was a Philippine senator, former Secretary of Justice, former chairperson of the Commission on Human Rights, who tried to block Rodrigo Duterte's drug war when she was initially elected, or the first time that she was elected as Philippine senator. But she was sent to jail for more than 7 years on trump-up charges that she was the drug queen, right? Right now, we were able to secure Laila de Lima's acquittal in all 3 non-bailable cases. There's not a single pending case against her in the criminal justice system. At least in courts right now, there's a new one, right? Filed by the Dutertes again, because she is investigating the Dutertes again for corruption, and they filed a case against her for supposed violation of the Bank Secrecy Act, which is a sham case once again, because the Anti-Money Laundering Council report was subpoenaed by Congress, and she is a member of the Congress, and it's not all members of the Congress who were sued, but only a handful of them, including Laila de Lima. But I guess even though Laila de Lima was gagged into submission, they attempted to silence her. They attempted to crush her spirit. She never, not a single day did she give up. Not a single day did she say, "I cannot do this anymore." For 7 years, she was virtually in solitary confinement, especially during the pandemic. But she still fought the drug war. She still released handwritten dispatches from prison. She was able to file 700 bills and resolutions as a Philippine senator, and was able to pass, at least as principal author, at least 4 major laws during that time. It goes to show that the human spirit and those people who stand up for human rights will be vindicated one day. And you know, she's back in the House of Representatives serving as a party list representative, and she will also be one of the main prosecutors in the impending impeachment trial of the daughter of Rodrigo Duterte, the Vice President of the Philippines, Sara Duterte. So at least there's vindication and empowerment. At least there's global model for advocacy. I was talking to Amnesty International that a lot of their political prisoners, eventually, even if they're campaigning for their freedom, a lot of them eventually end up dead, unfortunately. But it's very rare that they see a success story in the likes of Laila de Lima, and that can be a global model for advocacy as well, and a warning to perpetrators that human rights advocates, if they speak up, and if they have and if they're not if they are unwilling for their advocacy to stop and their spirit to be crushed, there will be people who will do that, and will be ready to fight, and give it their all. And that's a warning to perpetrators, because I believe that perpetrators are only brave if they know that no one else will fight back. So as I mentioned, there's a national implication. That's Bato de la Rosa, the picture to the right, running in the fire escape when he was being chased by the National Bureau of Investigation, our counterpart of the FBI and the police, to serve the ICC warrant before the shootout, and before he was given protective custody by the Senate President of the Philippines, who was Duterte's Foreign Affairs Secretary. So it means that we also have we are to also confront our own institutions in the Philippines, to make sure that at the very least we improve these institutions and we allow them to work. So domestically, we are also at a crossroads, and hopefully with the ICC trial, and once we finish this, or in the process, because there's also a cathartic effect of that, we would have at least international consciousness and part of our national discourse on how to move on from this horrific part of our history, no? And of course, the impunity happen in our country. We're trying to fight it through the help of the international community and through the help of international mechanisms. But the question of transitional justice remains. How do we make sure that domestically, at least in the Philippines, we would be able to recover and recuperate from this nightmarish experience? There has to be memorialization. There has to be some sort of compensation and rehabilitation for the victims' families. We have to have a national commitment that this will never happen again. And I don't think there's any effort from the Philippine government or from the public sector to at least have a transitional justice mechanism. Just last week, there is now a truth commission established. And this is good news, and this is for human rights advocates like me in the international community. I think you have to take a look at this. But this Truth Commission was established by the guidance of the Catholic Church and by the private sector. It's now being led. The Truth Commission is now being led by former ICC judge, the only Filipino ICC judge, the former dean of the University of the Philippines College of Law and a Harvard graduate, ICC Judge Raul Pangalangan. He said yes. I interviewed him last week, but it is quite difficult. And I was asking him, how do you expect for the Truth Commission to work? Well, in fact, it was launched by the private sector. Where will you get your funding? It does not have subpoena power. So how can you produce evidence? How can you compel people to tell the truth? How can you protect the victims if they would be telling their story and make sure that they will not be subject to any kind of retribution? All of those questions are valid questions, considering that our transitional justice mechanism is being undertaken by the private sector. And I'd like to, of course, remind everyone, as we all know, that every single time that there is a crimes against humanity, war crimes, the most horrific, the most atrocious crimes, that's the reason why there's universal jurisdiction, is because it's not only the Filipino people who's the victim. We all lose our collective humanity one way or another if we allow atrocity to continue. So I think the question now becomes, what then is supposed to happen, considering that we all now acknowledge, even the ICC acknowledges, that the Philippines suffered from crimes against humanity, from the most horrific kind of crimes, right? And there has to be some sort of program, or at least lens for international human rights groups to assist and to at least study the case of the Philippines and propose mechanisms to allow it to move on from this dark chapter and to actually install transitional justice mechanisms. So I think this has to be a global discussion, not only by the international community, but particularly by the human rights community. That's it. Thank you very much.
Thank you, Dino. So we are a couple of minutes away from our official closing time. And I did not ask speakers if they are willing and able to stay past the hour. So anyone who needs to leave, we thank you for being here. But anyone who would like to stay, speakers or otherwise, I will keep the meeting open for as long as we have questions and points to make. And so on that note, do we have any questions for our speakers? Sarah, you've raised your hand.
Yeah, I just think it's important, given the audience we have here today, to note that we recognize these acts aren't just illegal, but they're bad policy. And it's one point the coalition, a few of us are a part of, is trying to push, because this is bad policy to counteract drug trafficking. It doesn't work. It's not working in the United States. It didn't work in the Philippines. It's not going to work anywhere else. And continuing these policies only, creates new precedent for other countries to do the same and commit these kinds of terrible violence with impunity. But I think it's important for the public to understand, who might actually be supportive because they're angry about drug trafficking, that this is bad policy and it doesn't work and it's not going to help anyone. And so we do recognize that, even though a lot of what we spoke about today are legal issues.
Thank you, Sarah. Any Any questions or comments?
Hello,
Hi,
Aurora here.
Warang from the Philippine Coalition for the
Yes.
ICC.
Yeah, I have a question for Sarah. In fact, I put it in the message. But anyway, how does universal jurisdiction really work? What are the requirements, and uh, how different are they from the Rome Treaty, the Alien Tort Law, or how the ICJ work? Does it involve, is it individuals that are made accountable or states? I hope you can clarify this. Thank you.
No, it's a good question. And I probably should have been a little more specific and nuanced in talking through the international accountability options, because some of them are for prosecuting individuals, like in foreign courts, the UJ jurisdiction, and some of them, like the ICJ, an ICJ opinion would only be about state behavior and not about an individual. But the universal jurisdiction is like it's a very contemporary thing. It's a progressive application of international law where a state, as a matter of their domestic law, would pass a statute saying we have universal jurisdiction over these crimes: genocide, crimes against humanity, war crimes, and we will prosecute those. We will prosecute individuals that we can bring into our custody for these crimes, no matter if it was on our territory, no matter if the victims were our citizens or not, no matter if the perpetrator was our citizen or not. And so that's why it's called universal jurisdiction, because they're saying these crimes are so bad that we are going to pass a statute that would give us jurisdiction to prosecute, irregardless of our connection to the crime. Because as a matter of global community, we want to make sure that there's not impunity, and we want to make sure there's a space to prosecute for these kinds of crimes. If the state's not a party to the ICC, there are ways many individuals for these crimes can get away with them, as we've seen over history, right? So it is prosecuting individuals, and it's state by state, and the universal jurisdiction statute they pass is going to be specific to that state. It'll be different from other states. John, did you want to add anything to that?
Yeah, Aurora, you mentioned the Alien Tort Statute. I think that the Alien Tort Statute is like the closest thing that we have to universal jurisdiction in the United States. It certainly was not passed with this concept in mind. It's much older than, as Sarah said, universal jurisdiction is a pretty contemporary idea. It is like largely like a concept that came out of the 20th century and even the late 20th century, I would say. Whereas the Alien Tort Statute originated in the 18th century in the United States with piracy in mind above all, and was then repurposed in the late 20th century in order to jerry-rig, I guess might be a good way to put it, to improvise a version of what looks kind of like universal jurisdiction in the United States. The classic case of universal jurisdiction was the prosecution of Augusto Pinochet in Spain. And the other thing that I'll mention here, and Sarah has brought this up also, is that oftentimes the political consequences for universal jurisdiction can be decisive and can be quite influential in the willingness of a state to bring universal jurisdiction prosecutions, because it does have to be a decision of a prosecutor, often a prosecutor who's affiliated in some way with the government in the state that has universal jurisdiction. And so states are able to push back. They're able to try to impose consequences for states that do bring universal jurisdiction cases. And so, as is unfortunately often the case, we see that there's a strong interaction between the politics, the law, and the actual accountability outcomes that we see in universal jurisdiction cases.
I would also add the other close statute in the United States now is the War Crimes Act, which would allow for prosecution of perpetrators, even if they aren't citizens of the United States, for committing war crimes. We had in the past, the U.S. has had proposals for crimes against humanity statutes that have not been successful for a variety of reasons. And so that's why I spoke about the murder statutes at the top of this, because they're the closest thing for criminal prosecution in the United States. I didn't talk about the War Crimes Act because these aren't war crimes. This isn't a war. Yeah, and I didn't talk about the War Powers Resolution, which is a lot of the debate in Washington. It's over war powers, but this isn't a war. Again, these are just these are not just, but like these are EJKs. This is a human rights issue. It's a law enforcement peacetime issue. But the War Crimes Act was amended recently to have broader jurisdiction, closer to a universal jurisdiction type of situation. The problem is we don't have the same for crimes against humanity. Yeah.
Thank you. Thank you for all those explanations.
Thank you for joining us here, Aurora. Do we have more questions or comments? Well,
Can I just add one thing, David? I do hope those who are part of the UN system or have any influence at the UN considers the advisory opinion route. I think it's a really good one. I think it would put a lot of pressure on the administration to have the General Assembly pushing for an advisory opinion on the boat strikes. So if any of you have influence there, please push on that.
Thank you, Sarah. And I'll close out first by reiterating, as John noted, it's horrifying, not only the killings, but that the government is playing all of these videos consistently. And correct me if I'm wrong, Aurora, but I think this this kind of direct display of visually glorifying the violence in the Philippines mainly characterized the earliest parts of the Duterte drug war. Whether I'm right about that or not, I'll also note that there's another way in which the Trump administration has gone further than the Duterte administration. In the Philippines, while President Duterte took credit for the killings publicly, the people working for him attempted to explain it away, said he was joking or he was sending a message to criminals, or mostly that these were people who fought back against police, and that's why they got killed. Trump officials, by contrast, for the entire time so far, have directly asserted an unchecked right to kill. That goes further, and it has implications, especially coming from the government of what is still the world's most powerful superpower. And one of the reasons this could happen is the reticence, relatively speaking, of policymakers. Most members of Congress in the US, even leaders from Europe, and certainly in the region, have been slow to say that murder is murder and that these are murders. And this can be understood in a number of ways, given all of the adventurism, to use the term charitably, of the Trump administration, all that Europe has at stake right now, security-wise. But we don't know where this is going. We don't know what other countries this may be going to. We don't know whether it could come to our streets here in the United States. And so we believe the boat strike should continue to, should be one of the issues centrally included in the discussion of today's foreign policy crises, so that we can ensure that in part that accountability will only be a matter of time. So thank you all for joining us today.